when we sit down with potential franchise businesses, so someone's got a great brand and wants to roll it out, we get to the conversation of, and you'll need a franchise agreement, a legal agreement in place. And they will say, oh, I've got a friend of a friend or a family friend who's got a franchise agreement. Can we just use theirs?
Yeah.
And I tend to say no, because I can hear you at the back of my head say, absolutely not, Nick. But what's the view on modifying a current or an existing franchise agreement, or what's your view on that topic as a whole?
Okay, so the first piece, I know somebody who's got an agreement, can't I just use theirs because it worked for them? The problem is when I say this, everyone's going to say, well, you would say that because you're a lawyer and you want to charge for a whole new agreement.
But they might be in plumbing and the food is the other one, but anyway.
But that's the whole thing. Yeah. Just as I've always said, just like no two businesses are the same, no two franchise agreements are the same either.
Yeah.
You talk about an extreme example, and we've all seen it, where somebody has tried to modify a fast food franchise agreement to work for a gardening business, and it is so wrong. I mean, it's funny if you're not involved in it. If you're involved in it, it's tragic.
Yeah.
And it will never ever work with the best will in the world. Every agreement that we do is tailor-made for that client.
Yeah.
You can't put every potential clause in under the sun that could ever apply to anybody. So the agreement has to hone in on what actually matters to that franchise, what actually matters for that system, and not put in all the rest of it. So using somebody else's agreement, and even that agreement might have been dreadful for all we know.
And dated, I suppose.
And dated, and pointed in the wrong direction. For what it's worth, if you are going to develop a successful franchise system, as you well would have said yourself, you're doing it for the long term.
Yeah.
So to cut corners in the early stages by trying to work with a NAF agreement on the cheap is such a false economy.
Yeah.
So then your second question is about modifying an existing one. Now, it does happen to us quite a lot that clients say to us, well, I'm beginning to understand that my franchise agreement isn't really quite good enough.
Yeah.
And all the BFA don't like my franchise agreement. Can you just make some changes to it? Now, then there are a couple of possibilities. One is sometimes, depending on the agreement, we can just say, okay, we'll make a couple of changes. Where the agreement is absolutely shocking, we will never say that.
Yeah.
We will always say it's better to start again from the beginning. It takes us less time as lawyers to start
which is
again,
less cost, I assume.
and therefore less cost
Yeah.
than it is to fiddle.
Yeah.
But the one major flaw with this is if I were to just tinker with an agreement that you've done because somebody said you haven't got the right data protection clauses in there, you haven't got the right renewals in there, I could just change those two bits. But I don't know that anybody ever drafted the rest of it properly with your business in mind.
Yeah.
So I can look at 20 rights for termination. I don't know if they apply to your business or not in practice because I don't know. I don't know your business. So there can be a false economy. Yeah, we can change two clauses, but then we are absolutely not underwriting the rest of the document, and we are not promising you that the rest of the document is right for you. So you can pay us money in the end that's completely wasted because yes, okay, you'll have a data protection clause that works, but if fundamentally your franchise agreement was pointed in the wrong direction, we won't know that without taking proper instructions from you.
Yeah.
So in summary, I would always say, if you want to develop a franchise, you've got to do it for the long term, and cutting corners and doing false economies in the early stages is never going to be a good idea.
Okay, a slightly more credible question on a similar theme. What about international? So we're bringing in a brand at the moment, and we're working on it together, and they've got an international agreement. So a lot of the agreement should be purely relevant for their current location, but they want to come to the UK. And so I know we've got a different topic, or we've got a different time to discuss that topic in more detail, but what's your view there in terms of using their current or adapting?
Yeah, I mean, this is always a tricky one. The annoying thing is that, at the risk of stating the obvious, the law in different countries is different. The whole basis for construction of a legal system in one country is different to another. So it can mean a French agreement, for example, is never going to look anything like an English agreement, because the French have a coded legal system where a lot of how you treat a third party in a franchise agreement or any other agreement is already prescribed in some statutes. It isn't under English law. So you're going to have to start the agreement from a completely different basis. Then you've got the fact that different countries have different laws relating to franchising. So some require a disclosure document, some require a right for the franchisee to change their mind, some have registration requirements. So again, unfortunately, the reality is that it is a cost of doing business in any other market that you have to start again with the franchise agreement, pull operational details from the agreement that you had done locally into your new international agreement, but you are necessarily going to have to change it to make it work for a different country. And there's no shortcut way around that, unfortunately.
No, perfect, thanks.